It was a packed courtroom in December 1868 in Richmond, Virginia, the former capital of the Confederacy, where Chief Justice Salmon Chase ruled that defeated rebel President Jefferson Davis should not be charged with treason. Little did anyone know at the time that the Chase decision, along with a decision the following year that addressed the same legal issue but reached a different conclusion, would emerge from the mists of history to influence the ongoing debate over whether former President Donald Trump should be impeached. Both Chase cases, one of which involved a black man trying to overturn his felony conviction, will appear in court before the Supreme Court's oral argument in the Trump case next week. In all cases, Chase sat on a lower court, so he was not the Chief Justice. Both present a rare contemporary discussion of Section 3 of the then recently enacted 14th Amendment to the Constitution. The purpose of the provision was to prevent former government officials who joined the Confederacy from serving after the Civil War. It says that those who previously swore to uphold the Constitution and then participated in rebellion or insurrection cannot serve again. Chase's decisions took on new meaning when the Supreme Court heard Trump's request not to disqualify him from the Republican primary in Colorado. He wants to overturn a Colorado Supreme Court decision that found him ineligible for Chapter 3 because of his role in nullifying the 2020 presidential election in the series of events that led to the January 6, 2021 attack on the Capitol. I don't know that any single case or justice from the past is the dominant theme or the talisman that the court is looking at, said Vikram Amar, a professor at the University of California, Davis School of Law, which filed a letter citing the Chase decisions. But he added, if you're trying to convince people of the understanding of the day, you definitely want to consider what dignitaries said and did at the time. History is important in part because several members of the conservative majority Supreme Court placed great emphasis on how people would have understood the provisions of the Constitution at the time they were written. Chase, who had presidential ambitions, was an anti-slavery Republican former governor of Ohio who was appointed to the Supreme Court in 1864 by President Abraham Lincoln. Even as Chief Justice, he watched over the president, and historians say his decisions were influenced by political considerations. With the Davis case before him, Chase tried to win the Democratic nomination for president, although that attempt failed before he voted against impeachment. Cynthia Nicoletti, a professor at the University of Virginia School of Law, who wrote a book about the Davis prosecution, said in an interview that Chase's argument in the Davis case was weird, that seemed to be politically expedient. I think hunting is a clever way to break out of the cocoon, he said. Chase appeared to buy the argument from Davis lawyers that Section 3, which clearly applied to the former Confederate president, was a penalty that prevented any criminal prosecution. The lawyers argued that Section 3 was self-operating, meaning that it automatically applied to Davis without Congress having to pass any legislation to implement it. Historians have concluded that Chase himself privately advised Davis lawyers to make that argument. But the next year, Chase took the opposite approach in another Virginia case involving a black criminal prosecutor, Keezer Griffin, who argued that his conviction for shooting with intent to kill should be overturned because the judge presiding over his case was. Confederatist 3 appealed to the judge because he had previously sworn to uphold the Constitution as a member of the Virginia state legislature, Griffin argued. This time, Chase ruled that disqualifying someone under the 14th Amendment requires Confederate legislation, in part because of the far-reaching implications of thousands of decisions overturned by officials with the same Confederate background as the judge. In Griffin's case, the issue of enforcing Section 3 is one of several legal issues raised in Trump's case that could have far-reaching consequences if other states could follow Colorado's lead and remove him from the ballot. Trump's lawyers cited the Chase ruling in the Griffin case at the press conference, saying it helps establish congressional enforcement legislation as the only way to enforce SS3. That's just one of many arguments they make when they say the Colorado decision should be overturned. The plaintiffs, 6 Colorado voters, responded in their brief that Chase's opinion is non-binding and does not plausibly support the proposition that Section 3 is non-binding. They also highlighted Chase's controversial position in the Davis case. The Colorado Supreme Court said the Chase decision in the Griffin case was not persuasive.